Hello, a quick message from me before we get started. I've now hit 1,000 subscribers. To be honest, when I first started doing this, I was quite surprised when I hit 10 subscribers, so 1,000 is absolutely amazing, and it's a real inspiration for me to get on with things and make more videos in the future. Right, let's get on with today's topic, which is psychiatric harm. When we look back at older tort cases, it's actually quite difficult to find examples of psychiatric harm, and this is because of the lack of recognition given to psychiatric harm in the past. But as we move forward into the 21st century and there's a greater recognition of mental illness in general, we can see more cases involving psychiatric harm to victims being brought forward. Now, this does still have to be medically recognised as a psychological illness, and it has to go beyond mere grief, as was the discussion in Heavican and Ruane 1991. When we're looking at psychiatric harm in general, we can split between primary victims and secondary victims. So we'll look at primary victims first, and these are quite easy to deal with. These are people who suffer psychiatric harm after being physically injured themselves or put in fear of injury. And this was the formulation given in Page and Smith 1996. However, it is subject to a very narrow interpretation, particularly that being put in fear of injury. And this was the discussion in Rothwell 2006. Basically, we're going to only be talking then about people who are directly involved in the accident. Now, in White and Chief Constable of South Yorkshire Police 1999, it was expanded to include rescuers, and there have been other examples that are worth looking at where it has been expanded. A quick note before we move on to secondary victims, though, all of these cases that we'll go through involving the Chief Constable of South Yorkshire Police are all to do with the Hillsborough disaster, which was a terrible thing that happened at the Hillsborough Stadium in Sheffield involving a number of Liverpool FC fans. It was quite widespread in the news last year, but if you haven't heard of it, then it's definitely worth looking up quickly just to get a bit of a background towards it, because all of those cases that we're going to talk about involving the Chief Constable are all to do with the Hillsborough litigation. So moving on to secondary victims, here we have someone who is a witness to an injury or a witness to a situation where a person is put in fear of injury. And because there's a greater degree of removal from the actual accident itself, these claims are much more restricted, and in fact they're subject to 4 criteria that we'll go through now. So firstly, the person mustn't be overly susceptible to psychiatric harm. Borehill and Young is a famous case where a pregnant woman miscarried after she witnessed the aftermath of a motorbike accident. And Ms. Borehill, because she was pregnant, she was quite susceptible to the psychiatric harm. And basically the courts decided that because she only witnessed the aftermath, there wasn't sufficient proximate relationship to the accident itself so that she could bring a claim. Moving on from this, though, the J. and Coffey case is important the following year, because this discussion says that even when someone is susceptible to psychiatric harm, if a normal person of reasonable fortitude would still have suffered psychiatric harm, then the person will be able to make a claim as a secondary victim. The second criterion is they must have suffered the harm through shock. So they've come upon the accident and it's a complete shock to them. It's not something that they were expecting whatsoever. And this was discussed in North Glamorgan NHS Trust and Walters 2002. Thirdly, they must have been in physical proximity of the accident or the aftermath. A direct, immediate perception was the phrase used in another Hillsborough case, Alcock and Chief Constable of South Yorkshire. And the discussion in this case was quite interesting because there was a question about whether people who had watched the Hillsborough disaster on television were able to make a claim as secondary victims. But because they were only watching it on television, they weren't in physical proximity of the accident, they were not able to make a claim. The fourth and final criterion, they must have enjoyed a close personal or familial relationship with the victim. Now, in Alcock, there was a great discussion about what this involved, and things like parent and child and husband and wife were included. They also took it a step further to involve the personal relationship of a fiance, but there were a number of relationships that were quite controversially left out. So, a grandparent and a grandchild were not able to claim uncle and nephew, even brother and sister. And as we say here, in White and Chief Constable of South Yorkshire, which is probably the other main case on these secondary victims, if not the main case, it wasn't extended to rescuers in this instance either. So rescuers cannot be a secondary victim. There are a number of examples where there's a relational duty that automatically gives rise to a duty of care as regards psychiatric harm. So you can look at these cases yourself, but commercial relationship between a solicitor and client, schools and children, and doctor and patient as well. One of them that's not on that list is the employer-employee relationship, and you might think, well, this ought to give rise to a duty of care as regards psychiatric harm. But in the case of Alcock and Chief Constable, the discussion there said that it's not really about the relationship per se, but it's mainly about the activity that is being undertaken. In other words, it's important to look at the context. In Alcock, which involved a policeman bringing a case against his own chief constable because of the psychiatric harm suffered, the argument went that police officers in their line of duty should be not used to seeing accidents or aftermaths, but they should be more likely to see it as part of their normal duty during the day. Whereas if we compared that with someone who just works in an office, for example, the nature of that duty is quite different, and you wouldn't expect them to be seeing a terrible accident on a daily basis, for example. So before we finish, I want to talk a little bit about other types of harm as well. Psychiatric harm is obviously the complicated one that we've been talking about, but physical harm is also important. And the idea of what's caused, what physical harm actually constitutes has changed over the years as well because of different reactions from society. So McFarlane and Teesside Health Board 2000, McFarlane went for a vasectomy. The doctor didn't perform it correctly though, and McFarlane ended up fathering a child. He tried to get the health board to pay for the raising of the child completely, but the courts were never going to have that. But he still was able to receive compensation because a woman who he had had a relationship with gave birth to a child after he had had the vasectomy. And so our idea of what constitutes physical harm can vary depending on things like what medical procedures are available. I think if you'd have said 50 years ago that impregnating a woman would constitute physical harm, people would probably be repulsed by that. But given the context of the vasectomy, it's perhaps a little bit more understandable now. So we do have to look at the context of the physical harm and also the social considerations that I've mentioned there as well. And very finally, pure economic loss is also a type of harm as well, and this is a loss that is 100% financial in nature, as you can probably guess from the name, pure economic loss. And there we have the different types of harm that are available in tort law. I think that when people are answering either an exam question or a coursework on tort, there's a tendency to do all of the really complicated stuff like the duty of care, remoteness, causation, and forget about the harm that has actually been suffered in the end by the claimant in the case. But this is an area where you can often pick up quite a few marks, and they're not always the most difficult marks to pick up either. Well, thank you very much for watching this video. If you did enjoy it, make sure to leave it a like, subscribe for more videos in the future, and if you've got any questions, comments, queries, then leave those in the comments box below and I'll be sure to get back to you. Thanks as ever for watching. Bye!